Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Richard Peel, a Nevada construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Richard Peel.
Well, good morning. I hope everybody's having a good day so far. My name is Richard Peel, and I am a construction attorney. I've been practicing law for about 34 years in mostly Las Vegas, but we do work throughout the state. We have a construction boutique. I represent subcontractors, general contractors, owners, architects, and material suppliers. So we're all over the gambit. We've been on every major hotel casino project up and down the Las Vegas Strip, and we've also done work in Reno on some of the largest projects up there. I've had the opportunity historically of personally drafting many of our claim statutes that we enjoy here in Nevada. I started out in 1999 working on the prompt pay statute for public works, drafted that, got it passed into law in 2001, worked on the right to stop work statute in 2003, and then again in 2005 worked on amendments to the mechanics lien statute as well as the right to stop work statute, and have worked with the Nevada State Contractors Board over the last decade on a host of legislation trying to get their laws updated and passed. So let's get into it and let's talk about a contractor, subcontractors, and suppliers step-by-step guide to getting paid. So I think the first thing that will come up, if you have any questions, use the GoToWebinar chat box on the right. And so you'll see that, and that way I'll be able to see your questions. The questions will be answered at the end of the presentation. Please do not include your names. And please do not ask me questions that are very specific to ongoing projects. Basics of contracts. I want to talk about this first because I think that every relationship needs to start with a very good contract. So the first thing that you should always do as a contracting party is determine the position that you occupy. Are you an owner, an architect, engineer, a general contractor, a subcontractor, or supplier? Depending upon your position, whether you're a higher tiered party or a lower tiered party is going to be the reason why you're going to want to have that contract either more one-sided in your favor or less one-sided in the higher tiered party's favor. One of the things that I tell my clients is no one set of documents can be all things for all projects. And so everybody thinks that they have this magical contract, specifically general contractors have this view that their contract is perfect and they don't want changes to it and it's going to be good to go for every project. That's not the case. Every contract should be tailor fit for the particular project that the parties are going to be working on. Also, standard form construction contracts are not an exception to that rule. You have heard of the AIA documents, you've heard of the Engineer Joint Committee documents, even the AGC has produced documents that are usable by parties out there in the marketplace. Each of those sets of documents should be tailor fit for the project. With respect to who does a AIA document protect, keep in mind that it's generated to protect architects. And so if you're asked to sign an AIA document for a particular project, just be aware that that document is going to protect the architect. Many times the architect does not do contract administration, and because of that is not actively involved in many of the aspects of the project that the contract will address. And so again, that contract needs to be modified. The same thing is true about the Engineers Joint Contract Documents Committee. Those documents protect engineers. Likewise, the Associated General Contractors of America, AGC documents protect general contractors. My recommendation is to have an attorney, an experienced construction attorney, review all contracts. We have many out-of-state clients that will come into this state and they'll use their standard form of subcontract for purposes of contracting for a given project. Problem with it is that they'll get halfway into the project and realize that the terms and conditions don't marry up with many of the statutes that I started out talking about, whether it be the prompt pay statute for public works, right to stop work statute, or our mechanics lien statutes in this state. Let's get into Nevada lien laws. Who is a lien claimant? In Nevada, a lien claimant is a licensed contractor who provides work, materials, or equipment for a construction project with a value of $500 or more. One of the first assignments I got as a new attorney was to determine whether a person who was about 5 steps removed from a construction project had lien rights. And the more removed you are from providing work, materials, or equipment for a project, the less likely a court is going to find that you have lien rights. How do you perfect your lien? Well, there's about 5 different steps that you have to go through, and I call them statutory hoops that are very important for you to jump through in order to perfect your lien rights. The first thing you have to do is give or serve a notice of right to lien. You give a notice of lien or notice of right to lien by certified mail. You serve it by process. And it should be given by every architect, engineer, general contractor, subcontractor, and supplier of every tier. If you don't know whether you have a direct contract relationship with the project owner, you should always give a notice of right to lien. Now, many of my clients will make a determination based on their project size, or their contract size, I should say, as to whether to give a notice of right to lien or not. So, for example, if they have a contract that's less than $5,000, then they may not give a notice of right to lien. Whereas if it's more than $5,000, they will. And so you're going to need to be the decider as to what contract value has merit for giving a notice of right to lien. Keep in mind that this is the first key that unlocks the door to have lien rights. So again, if you do not have a contract relationship with the project owner, a notice of right to lien must be given or served. You must give your notice of right to lien to those who do not have a direct contract relationship with the owner of the real property, as I described. It should be given within 31 days of the first date you provide work, materials, or equipment for a construction project. Now, in 2003, when we made amendments to the mechanics lien statute, we went back in and we modified it such that the failure to give a notice of right to lien at the beginning of a project is not fatal. But keep in mind that if you do give it sometime during the course of the project, it's only going to relate back 31 days from the date you gave it. So to give you an example, if you gave it a notice to right to lien on February 1st of a given year, you would only have lien rights back to January 1st of that same year. So it would cover any work, materials, or equipment that you provide during that 31-day period going forward. The next thing that you need to be aware of is a 15-day notice of intent to lien. And back when we were trying to get amendments passed to the mechanics lien statute, the Southern Nevada home builders were very concerned because they wanted to make sure that before liens were recorded, that they were given notice that a lien was going to be recorded. And so they asked that a 15-day notice requirement be included in the mechanics lien statute. This particular provision is actually codified in 108.226 subsections 6 and 7. And so what I always tell clients is if it's a project where somebody can reside, then err in favor of giving a 15-day notice of intent to lien. Now, some of my clients have asked, well, what about mixed use projects where you have both a residential component, such as a condominium, plus you have a retail component? Do you have to give a 15-day notice of intent to lien? And again, I'll say the same thing. I would err in favor of always giving a 15-day notice of intent to lien if there is a residential component involved. In fact, the statute says that that if it is a single family or multifamily residence, including apartments, then such a notice needs to be given. I've broadened that and told clients at hotels, casinos also are projects for which a 15-day notice of intent to lien should be given. That 15-day notice of intent to lien should be given by every lien claimant. It should be given by personal service or certified mail. It should be given to the project owner and general contractor. Now, if you don't know who the project owner is, there's several different ways to determine that. You can go to the building permit that was pulled by the general contractor for the project, and you can determine who the owner's name is that's identified on the building permit. You can go to the assessor's office or the recorder's office and look up either the common address for the project, and if there is no common address, you could look at the APN with the recorder's office and try to figure out who the owner is. And if you were to obtain the information from the assessor's or the recorder's office as to the owner, that would be one of the ways of serving your 15-day notice of intent to lien. The same thing is true about your notice of right to lien. One thing that I'm going to tell you is once you identify that the owner is a entity, such as a limited liability company or a corporation, you can go to the Nevada Secretary of State, because every entity that does business in this state is required to be qualified. Some entities will be Nevada entities, and therefore they'll be front and center with the Secretary of State on their website. Other entities will be foreign entities, and they're required to be qualified. So you can serve an owner by serving their registered agent as well, as depicted in the Nevada Secretary of State's website. But you do need to give that 15-day notice of intent to lien to the project owner, and you should give it to a general contractor. Now, many times it's difficult to determine who the project owner is. I'll give you a real life example. Right now, I've got many clients who are on the MSG Sphere project here in Las Vegas, and the Sphere project is owned by a company called Venetian Venue Propco, LLC. It was a ground lease that was leased to MSG Las Vegas, LLC, and MSG Las Vegas is the project owner. And so there's also a general contractor that's involved. There was originally Hunt that was the general contractor, and then during the course of the project, it was assigned over to MSG LV Construction LLC, which is an affiliated entity to the project owner. So in that particular instance, if you were to give a 15-day notice of intent to lien, assuming it involved a residential component, which that project did not, you would need to give it to Venetian Venue Propco, as well as MSG Las Vegas LLC, the project owner. And then also you need to serve one or both of the general contractors, Hunt, as well as MSG LV Construction LLC. Now, the one thing that the statute is silent on is how long before you record a lien do you have to give a 15-day notice of intent to lien, assuming the project involves a residential component. And what I will tell you is that you should give it more than 15 days before a notice of lien is recorded. That's the safest route. I will also tell you that that there is no hard and fast rule. I've seen the courts in our state go both ways on this issue. Notice of lien. In other states, that's known as a mechanic's lien. In our state, we call it a notice of lien. And it must be recorded with the county recorder's office where the project is located within the earlier of 40 days of the date a notice of completion is recorded against the project, or 90 days of the date the project as a whole is complete. Now, I will tell you that there was a case that was that came down in June of 2023 by our Court of Appeals, and it stood for the proposition that a lien that was recorded more than 90 days after the date that the general contractor had stopped work, but before the project was complete, was too late to be effective. In other words, the court found that that lien had no merit. It went up to the Court of Appeals. The Court of Appeals affirmed the decision by the lower court, and ultimately it was appealed. And during the course of the appeal, a number of trade organizations filed amicus briefs with the court. In fact, we probably had about 15 different amicus briefs that were filed in that particular decision. Ultimately, the Court of Appeals, in my opinion, saw the handwriting on the wall and realized that they had really upset the construction industry, and that the construction industry had interpreted our statutory scheme in a certain way. And therefore, the Court of Appeals basically reversed their prior decision and remanded back to the lower court for further proceedings. So that case, which was unpublished to begin with, ultimately got kicked to the curb because of the fact that the court decided it was not going to follow the same direction that it previously was going. As of today, I think it's fair to assume that you have up to 90 days of the date that the project as a whole is completed. Now, that being said, I always tell my clients, don't wait that long. If you have not been paid within 90 days of the date you last furnished work, you should consider the possibility of recording a lien. Once you serve the notice of lien, it should be, or once you cause a notice of lien to be recorded, it should be served on the owner within 30 days after recordation. Foreclosure of a notice of lien, which would be filing of a complaint. An action must be commenced within 6 months of the date the notice of lien is recorded. If you don't timely commence an action within that time period, then your lien is considered to be void and of no effect. In other words, a hired third party, whether it be a general contractor or an owner, can move the court to discharge your lien of record and could seek attorney's fees. So it's very important that you jump through that statutory hoop as well. I want to talk briefly about the statutory waivers and releases of lien rights. Prior to 2003, Nevada did not have forms of waivers and releases to be used. Back at the time that the Venetian Hotel and Casino was being constructed, Lear McGovern Bovis, who was the general contractor on the project, was asking the trade contractors to sign a form of waiver and release that basically gave up on paper every right and remedy that that particular lower tiered trade possessed, whether it be your right to get paid for change order work, retention, etc. And ultimately, when we had a chance to make changes to the mechanics lien statute, we went through and we made sure that there were forms to be used in the state of Nevada. We have 4 forms. The first one is a waiver and release upon progress payment. It's a conditional waiver and release upon progress payment. That particular form is to be given to the higher tiered party at the time that you submit your pay application. The second form is an unconditional waiver and release upon progress payment. That form is to be given in exchange for the payment received. In other words, it's after you've already received payment for the work that was the subject of a prior progress billing. The third form is a conditional waiver and release upon final payment. That form is to be given when you're submitting your final pay app for retention. The last form is an unconditional waiver and release upon final payment. That form is to be given once you have received full payment for all work, materials, or equipment that you have provided for the project. Now, it's very important that you carefully select what form to use. I will tell you that general contractors and owners will ask you on occasion to submit waiver and release forms, for example, unconditional progress forms, when the check is not cleared to the bank. And that arguably is illegal under our statutory scheme. If you're a lower tiered party, you should never do that. If you're forced to do that, you should always send them a cover letter that basically says that they have demanded that you submit an unconditional waiver and release upon progress payment before the check is cleared to the bank. You're doing so under protest, and you reserve all your rights. Now, there's a safe harbor that's built into NRS 108.2457, subsection 5, that talks about what happens if the check doesn't clear the bank upon which it's drawn, that you're receiving in exchange for the giving of a waiver and release. And the answer is that You're only giving up your lien rights to the extent of the payment received. If you don't receive a payment, then arguably you have not given up your lien rights. So keep that in mind with respect to the statutory waivers and releases. The next section of the statute I want to talk about is prohibited actions in Nevada. We have a very unique statutory scheme, specifically 108.2453. That same statutory scheme is codified over in 2 different sections in the right to stop work statute. And it essentially prohibits contract terms that attempt to do any of the following. Require lien claimants to prospectively waive lien rights. In other words, you cannot prospectively waive your lien rights. It cannot relieve a person of an obligation required by the statute. In other words, if an owner is required to give some type of notice and they don't, then that obligation cannot be waived. It cannot make the contract subject to the laws of another state. Now, I will tell you that for state law purposes, arguably that particular provision is enforceable. For federal law purposes, there's an argument that it's not. It cannot require any dispute resolution that relates to a Nevada project to be conducted in another state. And the same answer is true about that as well. For state law purposes, it's arguably enforceable. For federal law purposes, it's arguably not. The last thing you need to be aware of is that a contract cannot force you to waive, release, or extinguish a claim or right for delay, acceleration, disruption, or impact damages, or an extension of time for delays incurred that were unreasonable under the circumstances, not within the contemplation of the parties at the time the contract was entered, or for which the lien claimant is not responsible. If any one of those 3 subset bullets take place, then you cannot give up your rights. Now, I tell you that, but I also tell you that judges in the courts have interpreted this statutory provision in contrast to contract language, and in some occasions they will have found that that this language does not prohibit rights for claims for delay, disruption, acceleration, impact, or an extension of time where you did not give timely notice of the event that is the subject of such delay, disruption, impact, acceleration, or an extension of time. So it's very important that you also comply with the contract requirements and you give notice. So I had about 15 to 20 minutes to talk. I'm happy to answer whatever questions that you might have. Like I said, I've been doing this a long time, so I have a wealth of knowledge that I can present to you, but I was trying to stay within the time constraints that we had. I know there's a pop quiz that you can also take that is up on the screen, and if you choose to do so, you can go ahead and participate in that. Well, any questions?
Yes, thank you so much, Richard. You were amazing. I really appreciate all your knowledge that you're able to impart upon us. We do have a couple of questions that came through. One is, how long is my lien effective on a commercial project?
So from the date that the lien is recorded, you have 6 months in which to file a complaint to foreclose on that lien. Filing of a complaint means you have to go to a court of competent jurisdiction, either the state court system or a federal court that resides in the state, to foreclose on your lien. Once you foreclose on your lien, that lien is going to be effective against title to the property until such time as it's been fully adjudicated, meaning a decision has been issued by the court, or alternatively until such time as the dispute has been settled. So again, these are statutory hoops. So if I were to back you up and go through the process, the first statutory hoop is making sure you give a notice of right to lien. Again, I recommend that it be done within 31 days of the first date you're on the project. That's to be given or served. The next issue that you need to address is a 15-day notice of intent to lien. If you're on a residential project, that should be given more than 15 days prior to the date that you cause a notice of lien to be recorded. The next one is the causing of a notice of lien to be recorded. And after it's recorded, you need to serve that notice of lien on the owner and the prime contractor within 30 days of the date that it was recorded. And then the last step that we talked about is the actual filing of a complaint to foreclose on the lien.
Okay, perfect. Thank you so much. And then the other question that we have is, it says, it's really frustrating if I haven't been paid, I have to pay for filing a lien. Can I get those fees reimbursed for like within the lien?
The reality is, and the answer is yes. 108.237 specifically allows you to recover your attorney's fees, costs, interest at prime plus 4%. But the reality is that most people, because of litigation fatigue, will end up settling before it ever makes it to a decision in a court of law. And because of that, generally when cases are settled, people do not recover their attorney's fees, costs, or interest. The paying party that is going to be paying you off is going to insist that you accept some lesser amount. I wish that it were opposite, but I can tell you that I can count probably on both hands the number of times that attorney's fees were recovered once the lien actually went to a decision by a court.
Okay, well, thank you. I appreciate that. All right, so if anyone does have a question that wasn't addressed, please feel free to reach out and we will be sure to answer any further questions for you. Richard, can you go to the next slide for me, please?
Sure.
All right, so this is that pop quiz that Richard was speaking about. Who is ready to win a gift? We're going to test your knowledge. If you can answer these questions correctly in the chat, we'll go ahead and send you guys over a little prize. Here are the questions. When does a subcontractor or supplier need to send a Nevada notice of right to lien? And then the other one is, when does a subcontractor or supplier need to send a Nevada preliminary notice on a state project? If you think you know those answers, go ahead and chime in and we'd love to send you guys over a little gift. All right, can you go to the next one for me, please, Richard? All right, so here are some of SunRay resources that can help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan this QR code to access these incredible resources. There's so much on there: project information sheets, lien laws based on which state your project is taking place in, deadline calculators, and so much more. So check it out and see how we can help you stay organized. All right, go ahead and go to the next one for me, please. Richard, next slide. Thank you. Perfect. It says, this is our new service that SunRay is offering. We have SR receivables. We'll handle your collections for you, and we are here to get you paid. So if you are curious, need to know some more information, please reach out to us, give us a call, and we'll walk you through that process. All right, go ahead and go to that next slide, please. All right, so Richard's next webinar that he's going to be hosting with us is Don't Sign a Release Unless It Says This One Thing. That's going to be on Tuesday, September 10th at 12 p.m. Eastern. So go ahead and register for free at sunraynotice.com/education. All right, next slide, please. Please take a moment to review us on Google. It helps us. We appreciate all the feedback we can get, and it helps to make sure that we're getting this information out to more contractors and suppliers like yourselves. And then the next slide. That is all we have for you guys today. Thank you so much for everybody that attended. We hope to see you at our next webinar. Thank you again, Richard. You really were incredible, and we hope you all have a wonderful and sunny day. Thanks again. Bye-bye, everyone.